Welcome to today's program, How and Why Texas is Different When It Comes to Trade Secrets and Non-Competes. Copies of the slides, a link to the recording, and the CLE verification form will be emailed to you in the days following the webinar. During the program, a CLE code will be read aloud, and you will be required to include this code on the CLE form. Throughout the webinar, please feel free to type your questions into the chat box on your screen. Now I'd like to turn it over to Jesse Coleman.
Good morning, good afternoon to everybody here on the call. Thank you for joining us today on a topic that is near and dear to my heart and the heart of the panelists here, how and why Texas is different when it comes to trade secrets and non-competes. Texas is different in so many ways from the other 49 states and other jurisdictions, and trade secrets non-compete is no different. Texas has its own way of doing these things, similar in some ways to other states, very different in others. And so we're looking forward to talking through these differences and similarities to help you in your practices, to help you in advising your internal clients and helping you navigate this landscape. So thank you very much for taking this hour with us here today. I have the privilege of introducing my colleagues. We three are going to be presenting here today. Matt Simmons is a senior counsel in the labor and employment section of Seyfarth in Houston, Texas. His practice focuses on restrictive covenant and trade secret litigation, as well as high-stakes employment defense litigation. Kevin Green is a senior associate in the commercial litigation section of Seyfarth Shaw's Houston office. Kevin's practice focuses on complex commercial litigation. He has experience in a diverse range of industries, including trade secrets, non-competes, healthcare, energy, construction, securities, business torts, and contractual disputes. He also has experience in state and federal trials, arbitrations, along with national and international disputes. So I've had the privilege of working with Kevin on many of these matters and can attest to how good he is in this area, particularly in trade secret non-compete work. So, and as well as Matt, we've all worked together on various matters as well as worked separately. I am a partner in the commercial litigation section, the Houston office at Seyfarth Shaw. My experience is also primarily in trade secret and restrictive covenant disputes as relevant to today's presentations. I also have a focus on commercial disputes in the healthcare industry. So we're going to go ahead and get started. We can go to the next slide. I'm going to give us kind of a general overview of what we're going to be talking about today. Kevin is going to walk through with us an overview of trade secrets and non-competes generally, kind of give us a baseline as to what we're going to be talking about, the general pain points and issues that arise when an employee either departs from an employer and has protected sensitive business information, whether it's proprietary, confidential, or trade secret information, and then has a potential restrictive covenants that are associated with that. Or as an employee has left that employer and comes and you are the new employer. We're going to look at what those issues are. Matt's going to pick it up from there and talk about how Texas is different from other states, how Texas deals specifically differently with non-competes, those areas in which you can see the similarities and those ways in which Texas handles this uniquely, this area of law. And then I'll round out the discussion at the end with how Texas is different for trade secrets. Texas has its own statutes, as all other states do, which in many ways is similar to the Uniform Trade Secrets Act, is many ways and similar to the Defend Trade Secrets Act, which is the federal law on trade secrets, but then has its own unique areas, which we hope to make you aware of today. So with that, we did have a disclaimer that we jumped over, I think, rather quickly, but the presentation here, informational purposes only. We're not creating attorney-client relationships here, as you know, intended for general information. And of course, you're urged to consult with a lawyer. I would recommend the two gentlemen here, and we'd recommend Seyfarth for those purposes if it's something that you need. With that in mind, we're going to go ahead and jump to an overview of trade secrets and non-competes and pass the baton to Kevin.
Thank you, Jesse. So as Jesse mentioned, my name is Kevin Green, and I'm going to just be giving a brief overview of trade secrets and non-competes generally, while my colleagues Matt and Jesse are going to provide more detailed information. Next slide, please. So as everyone on this call probably knows, the law on restrictive covenants varies significantly from state to state. That's the purpose of today's webinar. It's governed by common law, statutes, or some combination of both. Texas is generally both. And a restrictive covenant, generally, to put it just in more approachable terms, it's just a legal term for a clause in an employment contract or an employment agreement that prevents an employee from doing something. A Texas non-compete or non-competition agreement is designed to limit the place and nature of work an employee can do. And most often, non-compete agreements are designed to prevent an employee from leaving their job and competing with their former employer for clients or business. And this is because Texas wants to encourage businesses and promote healthy business competition, at the same time allowing employers to require employees to sign non-competes that protect those same interests. So generally speaking, restrictive covenants come in 4 different varieties, 4 different types of promises. The first is a promise not to compete with one's former employer. This is sort of the classic non-competition clause you might see in an employment agreement. The second is they're both non-solicitation type promises, a promise not to solicit or accept businesses from customers of the former employer, or a promise not to recruit or hire away employees of the former employer. And the fourth type is essentially non-disclosure, the promise not to use or disclose the former employer's confidential information. Texas does enforce restrictive covenants. There's statutory definitions and bases, which my colleagues will discuss, but broadly speaking, they have to be subject to reasonable limitations. And the most common ones are limitations with respect to time, has to be a reasonable time period, activity, generally broad, all-inclusive prohibitions on any type of activity are disfavored. So you have to be a little bit specific as to what activity you are protecting. And then there are geographic or customer-based restrictions as well. So don't compete in a particular area or for businesses with certain customers. Next slide, please. So enforceability of restrictive covenants is governed by state law, not federal law. Although, as Jesse mentioned, there are federal statutes, and if your cause of action is tied up with both, then you have to consider both. But enforceability varies from state to state. Certain restrictions may be enforceable in Illinois. They're definitely not enforceable in California. They are most likely enforceable here in Texas. So you need to pay attention to your state forum and choice of law provisions in your agreements in order to make sure you're selecting the forum that you either do business or you desire to litigate in. In general, states that enforce restrictive covenants require it to be narrowly tailored to protect legitimate business interests. And as we mentioned, there are reasonable limitations that must be included, typically geography, time, and the scope of that activity. A big element in Texas for enforceability of a restrictive covenant is consideration. The statute provides that at Section 1550A, a covenant not to compete is enforceable if it is ancillary to an otherwise enforceable agreement. Y'all have probably all heard that sort of language before, and my colleagues will delve into it deeper, but independent consideration is a key element for your non-compete to be considered valid in a court. And note that the burden of proof lies with the employer in these instances, so it's beholden to you as the employer to ensure that your non-competes and other restrictive covenants comply with the law. Next slide, please. So what remedies are available to you for violation of a restrictive covenant? Most commonly, you can obtain damages. The Act allows court to award employers damages, injunctive relief, or both for breach of a covenant by an employee. Damages include actual damages, not exemplary, unless there are separate tort allegations that are connected. You might have tortious interference with contractual relationships if they're soliciting your customers In those instances, there may be other avenues, but the Act itself does not allow for exemplary damages. And equitable relief is the other big sort of damages you get. So this can be alone or in addition to your actual damages. Typically, it's injunctive relief or reformation of the restrictive covenant and your agreement. So on injunctive relief, this is the classic temporary restraining order, temporary or preliminary injunction, or permanent injunction. And ultimately, what you're seeking, if you have to avail yourself of these procedures, is a court order, which bars that employee from working for a competitor, soliciting customers, or hiring employees, whatever the provisions of your agreement dictate. But you are ultimately asking for a sort of a permanent injunction, a court order detailing that this former employee is prohibited from this type of behavior. One note about attorney's fees: when you are seeking to enforce a restrictive covenant, generally you cannot get attorney's fees under the Act itself. The Act really provides only injunctive relief. Now, that being said, often this conduct that would violate a restrictive covenant is tied up in other conduct that might provide an additional or separate cause of action that is linked together that may provide for attorney's fees. Most common is breach of contract, right? You've got an employment agreement and you can seek them under that cause of action. But under the Act, the Non-Compete Act itself, you note that you are not able to obtain them for enforcing a covenant. That being said, and this is sometimes a trap for the unwary, the Act does allow for recovery of attorney's fees in defense of an action to enforce a covenant. So if you get sued by someone claiming that your new employee, is violating one of their restrictive covenants by their former employer, note that it is discretionary. It's permissive, not mandatory. And even then, you have to fulfill certain evidentiary standards, some of which, they're all in the Act, but some of which most notably are that the former employer knew those limitations were unreasonable, et cetera, et cetera. But there is a path on the defense side to recovery of your attorney's fees. Next slide, please. So that brings us to trade secrets. Historically, I think the Fifth Circuit has called trade secrets one of the most elusive and difficult concepts in the law to define. Thankfully, now it's defined by statutes. As Jesse mentioned, the Defend Trade Secrets Act. There's definitions, and my colleagues will discuss that in detail. But what is a trade secret in simple terms is it's simply a type of intellectual property that involves a business's ownership of a formula, pattern, compilation, program, device, method, technique, process that provides a competitive edge. It's intellectual property rights on confidential information that can be sold or licensed. So there has to be identifiable information that isn't known to others, i.e. you keep it secret. That's seemingly obvious, but often overlooked in much of the case law. It has to have some economic advantage, a competitive edge of some nature, and the company itself must provide reasonable efforts to maintain the secrecy of that information. So there's a picture there, which Coca-Cola formula is the classic example for what a trade secret is. Coca-Cola made the choice to brand the recipe a trade secret instead of patenting it, which would have led to disclosure of the ingredients. And according to the company, the original formula is written on a piece of paper stored in a bank vault with only a small handful of employees having access to at any given time. And it's important to note that while we often think of trade secrets as products, they also include know-how. So that's why I kind of gave that long, convoluted example up front of processes, methods, techniques, which is part of the definition. Processes, know-how, et cetera, as long as they provide a competitive advantage, are trade secrets. So some other examples would include the Google search algorithm. Not necessarily a product, but it is an example of a process that is trade secret protected. The New York Times bestseller list, and then there's some more product-based ones, but they're also underlined by processes such as the KFC recipe and WD-40. Next slide, please. So why are trade secrets important? They're important because they're big business, ultimately. I put some statistics up here on the slides that you can read, but bottom line, there's estimations by the U.S. Chamber of Commerce that publicly traded companies own approximately $5 trillion in trade secrets, and the economic loss from the theft of those trade secrets ranges from 1 to 3% of the U.S. GDP, which I think is between 20 or 21 trillion, equating to 180 or 540 billion dollars annually. Next slide, please. A vast majority of company CEOs believe that their trade secrets are vital, if not an essential part of their business. You can think back to the examples of Coca-Cola and Google. Obviously, those processes are vital to their continuing competitive edge. And 71% of companies believe that protecting trade secrets is a board-level issue, which makes sense when you think of the requirement that companies maintain the secrecy of these information. They have procedures in order to keep it safe. And in 90% of the trade secret cases that we've seen, the misappropriator is someone the trade secret owner actually knew, typically a former employer or business partner that disclosed it to them. Next slide, please. So trade secrets, generally, who is stealing them? The most common misappropriators that we've seen are rogue employees, business partners. These days, the vast majority of theft is by electronic means. And why is it done by employees and business partners? Well, these are the people who have access to and familiarity with the systems that store this information. And technology these days makes it easy. You know, there's many tools for exfiltration of data. Technology allows for remote and cloud computing. So generally speaking, trade secrets are stolen in one of three ways. The unauthorized access to a business information, misappropriation of a business's disclosures to third parties, or misuse of information by current or former employees, typically those who leave to start a competing business. Next slide, please. So how it's done. There's obviously a list on the slide of typical methods that we've noticed over the years. Going back to the broad category, unauthorized access, right? Every business has information systems, typically maintained digitally. Unauthorized access to those systems can result in the theft of trade secrets. Some are through hacking or data breaches, but others result from unexpected use of information a business intentionally makes public. So one example, a company's website offered individualized life insurance quotes to the public, and a competitor used a bot to generate and record 43 million quotes in 4 days, thereby discovering a significant part of their proprietary database. Misuse of disclosures, as I mentioned, is a general category here. You know, businesses have to transmit information to third parties, even under NDAs, and that can sometimes result in theft of trade secrets. Either the recipient itself might misuse the information, or sometimes those recipients disclose it to other competitors in order to help rivals compete in bids or other environments. And typically employees is sort of the last broad category, as we discussed. You know, this is where they have access internally to the system. This is the downloading hard drive is the typical example. Taking pictures internally of your proprietary systems. Obviously email, that is not a very sophisticated way, but it happens, and it leaves a trail. You know, if they memorize the information, that's certainly a way, and it's much harder to enforce. Next slide, please. So examples of trade secrets, as we mentioned, you know, it's important to keep in mind that you might think of it just as a product, but it is much more than that. And the definition of trade secret in the statute provides all of that long processes, methods, techniques, language that we discussed. But there's formulas, manufacturing processes, your marketing strategies, business plans, you know, your sensitive internal financial information, what you're paying employees, et cetera, that can be considered a trade secret. Your pricing cost information, of course, your software and source code. Your knowledge about customers and vendors, you know, there's such a thing as even negative information, right? Knowing where not to drill the oil well is also as valuable as knowing where to drill it in some instances. That's your negative research results, and then customer lists and know-how. Next slide, please. And so there's several key statutes that govern trade secrets. As mentioned, my colleagues are going to go through these in depth in their application to Texas specifically. But with respect to Texas, number 5 and 6 are the statutes that govern at the state level what we've been discussing. And there's the rest are federal. So you guys are probably all familiar with that. And my colleagues will discuss it further. I think with that, I'm going to turn it over to Matt Simmons.
Thanks, Kevin. Next slide. All right. So my name is Matt Simmons. I'm a senior counsel in the L&E section of Seyfarth here in Houston. I do a lot of restricted covenant matters. That's the bulk of my workload. The rest of the time, I get to spend doing employment defense litigation. Just like Jesse and Kevin, I represent plaintiffs and defendants in these types of lawsuits. So what I'm stating below are the general rules of the road. Yes, as lawyers on both sides of this issue, we create arguments to differentiate between the normal rule. And so I'm just giving you the general rule and how you should think about these types of covenants in your workforce. Next slide. All right, so Texas has the freedom of contract. That's the biggest thing that I get whenever I tell people that I'm a non-compete attorney or something like that. They say, well, Texas is an at-will state. Yes, it is an at-will state, but that doesn't mean what you think it means. You absolutely have the ability and the freedom to contract, but Texas obviously has some guardrails that we'll discuss further. Since the last year, Texas really hasn't changed much in terms of restrictive covenants or litigation or anything like that. But as expected, the rest of the states have continued to push forward to create a bigger hurdle for companies to be able to enforce these types of agreements. So, for example, Colorado is the big new one. Importantly, it's the first state to impose misdemeanor criminal liability for the use of force, threats, or other means of intimidation to prevent any employee from engaging in any lawful occupation. So we're not aware of any charges yet or whether the criminal liability statute for merely presenting an unenforceable non-competition agreement would actually result in criminal penalties, but they signed another new law after that, which imposes a $5,000 fine for an unenforceable agreement. If you want to learn more about it, our own Jesse Coleman has several articles on it on our blog, which is going to be referenced a little bit later. Texas versus California, North Dakota, Oklahoma, Washington, D.C. was on this list, and their non-compete statute changes more than a chameleon at a concert. So I think that Washington, D.C. is now falling within the other oddities, which are having salary basis tests on who and who cannot have non-competes. So that's the employee's salary. There's also a strain on whether the employee was terminated for cause or furloughed. Some states like Pennsylvania and New York have restrictions on whether the non-compete, even though it was enforceable, but at the time of the termination, for the reason of the termination, it becomes unenforceable. Other oddities, especially practicing in Texas, you likely have some employees that reside in Louisiana. And in Louisiana, in order for the non-compete or non-solicitation to become enforceable, you actually have to list the parishes that you want to enforce it in. There isn't a catch-all state of Louisiana or certain customers. You actually have to list the parish that you want to make it enforceable in for it to be enforceable. Then you have other states like Vermont that has different non-compete statutes and thresholds for barbering or cosmetology people. In Utah, it's for broadcasting industry. So you just have to be very aware of the state where your employees reside, the industry that you're in, to determine whether or not you have additional considerations that you have to make in order to make a non-compete enforceable. Consideration in Texas. Some states are different. In Texas, merely providing new confidential information in exchange for a non-compete or a restricted covenant is sufficient, but it still has to be reasonable in time, geographical area, and scope of activity restrained. Next slide. All right, so this is where all the gray area in Texas non-compete restricted covenant law is what is reasonable. And that's why there's lawsuits about it, because reasonableness depends on the facts, and the facts are different in every case. So the statute actually says that it cannot impose a greater restraint than is necessary to protect the goodwill or other business interest of the promisee. So in Texas, time, it's 2 to 5 years has been held to be reasonable. I will say in practice, 2 years is becoming more of the top end bar that a lot of the state district court judges don't like to exceed. So most of the agreements that I see today and most of the advice that I give to my clients in terms of reasonableness is really 1 year to 2 years maximum for a non-compete. Geographic area. There's many ways to satisfy the geographic area prong in the non-compete test. One way is really just to define the geographic area as the employee's scope of responsibility or activity while he was within the company over the last 12 months or 2 years. It's always good to have a look back period, because if you have a 1 year or 2 year look back period from the date that the employee, their employment's terminated for whatever reason, it's more reasonable, because if you're trying to say, hey, employee X shouldn't be able to work in Idaho because they solicited a client there 5 years ago, that could be held to be unreasonable because there isn't really any goodwill or protectable information or business interest in that state. So having a look back period of 1 year to 2 year is a great way to limit it, make it enforceable, and narrowly tailor it to what your needs are. Also limit the customers the employees had material contact or received access to confidential information about during the look back period is another way to satisfy the geographic area responsibility in the state of Texas. That is different than some other states. Scope of activity restraint. This is the biggest issue that I see in most agreements that I litigate or review or revise. So we call this the janitor rule. If your non-compete agreement would prevent an employee of yours from being a janitor at a competitor, then it is unenforceable under Texas law. So you have to limit the scope of activity restrained to the same or similar duties that the employee was doing for your company for the competitor. So that's another way that Texas law wants you to narrow your agreement so that they become enforceable and so that they're actually there to protect the goodwill and business interest of the company. Next slide. All right, non-solicitation. This is more enforceable in other states, but than a non-compete, and it is certainly a growing trend that most companies, for non-executives, are getting rid of the non-compete and really focusing more on customer and employee non-solicitation. In Texas, a lot of the all the requirements for a non-compete also have to be satisfied in a non-solicitation. But and the enforceability is governed by the same statute, same reasonable standards. Most list And the most common issue that I see in employee or customer non-solicitations, really employee non-solicitations, is you have an agreement that states you can't solicit any employee of the company for 1 year. Well, as written, that's unenforceable in Texas. You actually have to narrow the scope of what you define employee, a restricted employee, to be an employee that the employee that's leaving had access to or managed or otherwise had substantial contact with while that person was employed by you. That way, it's narrowly tailored to limit the restriction to just the issues that you're trying to resolve, which is them stealing people on their team, not, you know, some random employee in Canada that they never heard of, but, you know, ended up on their radar in the non-solicitation in their new company. Next slide.
Hey, Matt, I have a quick question for you, if you don't mind, before we move off this topic.
Yeah.
One of the areas that you identified as impacts the scope of a legitimately enforceable non-compete is geography, and that's going to be looked at carefully by the court in order to determine whether it's larger than what's necessary to protect a legitimate business interest. How has that factor, in your experience over the last year, been impacted by an increasing remote workforce? Do you see that employers are having a harder time identifying those geographies? Are they spending more time trying to identify what they are, or do employers tend to rely on the other scopes to kind of define what's going to be protected?
Yeah, sure. Great question. I think there's actually two issues that come into play in terms of remoteness. So the first issue is what you talked about, which is, you know, where exactly are the clients or customers or base that they have. Now, if the employee has a set territory, that's easy. You know, if they're territory manager for the Houston area, that's easy, and that's the area. It has been a little more difficult because certain companies are expanding beyond their normal scope because they can, and they don't have to have a brick and mortar office in a lot of these other locations. So, you know, it has been difficult, but if it's specific enough to cover where the employee is providing services or pitching for services, then it satisfies it. Another consideration, the second consideration is, yeah, it's great to have a choice of law provision in any of these restricted covenants, and sometimes it will control, but most of the time, I would say, you know, almost all the time, it's really where the employee resides, right? Because most states have a fundamental right of protecting their employees' ability to work. And if that state that they actually reside in or move to after they sign an agreement is different, more restrictive in terms of enforceability, typically that state's law that they move to will control over any choice of law provision that's in your agreement.
Thanks for that, Matt.
Yeah, absolutely. Next slide. All right, same thing in terms of state law. Each state has a different way of curing unenforceable restrictive covenants. You have blue, red, and purple pencil states. You know, red pencil states, one provision is overbroad, the whole covenant is unenforceable. Blue pencil states, one provision is overbroad, the court in the state is actually told to remove just that overbroad portion, but not rewrite the contract to make it reasonable. Purple pencil states are required, the judges are required to reform the agreement to make it reasonable. Texas is a purple state. Section 1551C requires that the court reform the covenant to the extent necessary to cause the limitations contained in the covenant at the time, geographical area, scope of activity to be reasonable. There's other states that have issues related to enforceability and, whether your agreement's enforceable, you also need to know if it's reformed, what the ramifications are. In Texas, if it gets reformed, you can't get any damages for any time before the cause of action is reformed. Next slide. Another point of issue in terms of reformation is, at least in some instances in Texas, there is some fairly new case law where if the reformation takes place after the agreement's time lapses, so let's say it's a 1-year agreement and you get reformation after 1.5 years and don't get any injunctive relief, courts have held in Texas that the agreement is no longer enforceable because it didn't have a time lapse tolling clause and there was an injunctive relief prior to that. In a lot of the major counties in Texas, especially Harris County and Houston, Texas, where we reside, in order to get a trial on the merits of a case, it can be 4+ years. That's typically the standard right now in state court. So if you don't get immediate injunctive relief or don't ask for it, you do have a potential issue of getting your non-compete enforced at the end of the day, because if the time has lapsed and you don't have a tolling provision, you don't get any relief in terms of an injunction. Fixing agreements. So after going through some of these non-compete, non-solicit issues, you may realize, hey, I may need to change it and have it enforceable. Consideration's key. First date of employment is great, but if it's a current employee, it's a good idea to provide consideration in terms of new confidential information. I always recommend to my clients that whenever they send out new agreements, new revised restricted covenants, to provide the new confidential information, whether it's a new client list or a new lead or something new, financial report, forecast, anything like that that would be considered confidential information or trade secret that they didn't have previously, and document that within the employee's file so that they don't have the argument that they didn't receive any new consideration in exchange for their signing a revised non-compete, non-solicit agreement. And always ask for our 50-state survey. We do have a survey that provides general guidelines on all 50 states to help you at least know what the questions are, look at the statutes, and have a starting point for your talk with the Seyfarth attorney. Next slide. All right, pandemic issues. So, yes, the pandemic is still going on in most states, but really what happened with the pandemic is it further solidified a trend within the courts, especially in Texas, to take equitable considerations over applying the law as it's written, because again, there's factual circumstances. So some of the things that you should consider in terms of what injunctive relief you should seek and what injunctive relief you'll actually get in a Texas court is really, was the employee terminated or did the employee resign? Obviously, a court, for equitable reasons, would favor enforcing a non-compete or restricted covenant over an employee that chooses to go somewhere else. Same thing with the employee's position and job duties. If it's an executive, more likely to get enforced versus a janitor or a low-level salesperson with not a lot of goodwill. Also, if the person's going to a new employer that's already a competitor or starting up a new business, having the personal share of taking information, goodwill, that also loops into whether the courts will enforce the non-compete as written or adjudge some sort of smaller relief that allows the person to continue to operate within their business and under certain guardrails. Same thing with the economics of city and the region. During the pandemic, some regions got hit harder, but right now, Unemployment rate is down, but a lot of the larger cities in Texas still have a liberal stance in terms of enforcing these agreements in full. And so be aware of that whenever you look at whether to even bring it in state court, if you could potentially have a federal cause of action. I'll turn this over to Jesse.
Thank you, Matt. Before we leave non-competes and non-solicits, I want to touch base real quick on an issue Matt raised, and that is the enforceability of form selection clauses. Matt is absolutely right that this is a hot button issue. Courts, depending on the state, there are many states now that are enforcing that are refusing to enforce choice of law form selection, venue selection clauses because they see a fundamental interest in the state to enforce the choice of law for their residents. There are other states, however, that do recognize and enforce form selection clause. Texas is actually one of them. So you want to take a look at those issues, particularly in the realm of non-competes, non-solicits. It may greatly impact. Matt, have you seen this play out? I know there's a federal circuit, if not a circuit split, certainly within the districts, trying to interpret the Atlantic Marine case, for instance, as to whether or not form selection clause should be enforced, even when the employee, for instance, has no connection to the forum state. Other than agreeing for that forum to be the choice of law for their restrictive covenants. Have you seen any of that play out with your clients or in the case law?
Yeah, so in terms of clients, really the issue comes up into whenever you're being the plaintiff, right? And you're wanting to go after specific relief. Where do you bring the lawsuit? Is it where the forum selection is, or is it where the employee resides? Because a lot of the times these non-compete trade secret lawsuits, they're very expensive up front, and to add on top of everything a forum selection jurisdiction issue, a lot of the times it's if the two laws, substantive laws, don't conflict, then it may be, I do advise clients to sue in the state of residence of the employee, even if it isn't the choice of law, and leave that choice of law venue consideration really for the next step so that you get a clear win or a clear decision without having to wrestle with the forum issue, but you can still argue that the choice of law is either Texas or whatever, Delaware or something like that. So that's what's come up, really not substantively with whether it's enforceable, but really what forum to bring it in.
That's great. I appreciate that insight, Matt. Before we move on, I'd like to provide the CLE code, which is required on the CLE verification form that will be emailed to you in the days following the webinar. The CLE code is SS4538. That's SS as in Seyfarth Shaw 4538. Moving on to my section of this presentation, we're going to talk about how Texas is different regarding trade secrets. Every state has a different regime governing trade secrets, and Texas is no different in having its own different way of doing this. Next slide, please. The Texas legislature enacted the Texas Uniform Trade Secrets Act, or TUTSA, on September 1st, 2013. It was based on the Uniform Trade Secrets Act that serves as the model for almost every other state that has trade secret laws. It, in general, allows for injunctive relief against trade secret misappropriation, and also identifies the types of damages that can be recovered, and we'll talk about that. These would include actual damages, unjust enrichment, exemplary damages, and attorney's fees under certain circumstances. One of the most interesting things about it is that it provides a presumption in favor of granting protective orders in order to preserve the secrecy of trade secrets throughout the litigation. This is a bit of shift of the burden from other cases in commercial disputes. In May of 2017, 2017, the legislature amended the TUTSA, which is located in Chapter 134A of the Texas Civil Practices and Remedies Code, to align it more closely with the federal law, the DTSA, and recent judicial interpretations of the law, in particular a case called MILLCC SWACO. We'll talk more about that case. It updated, for example, the definition of who an owner is, that is the person or entity in whom or in which rightful legal or equitable title or right to enforce rights in the trade secret is reposed. This is primarily the same as the DTSA, the Defend Trade Secrets Act, the federal law, though not verbatim. It also identifies what constitutes willful and malicious and what quantum of evidence is necessary for clear and convincing evidence, which are both required elements for certain types of relief under the statute. It also codifies the Supreme Court's holding in that MILLC SWACO case, which set out a 7-factor balancing test that courts must consider before excluding a party's representative at any stage of the proceedings. We're going to come back to this case again. It's a fascinating case because it also provides evidence that the Texas Supreme Court may be in favor of certain versions of the inevitable use or disclosure doctrine. It made some particular holdings and findings about how an individual cannot bifurcate in their minds trade secret information that they may have learned if they're within a role that involves business decisions. But ultimately, the TUTSA adopted the 7-factor test as to whether to exclude those representatives during the process. As you can see here on the slide, the primary elements of establishing a claim are the existence of the trade secret, the ownership, acquisition by improper means, and that the defendant used or disclosed or threatened to use or disclose trade secrets. Next slide, please. So there are some key differences between the DTSA and the TUTSA, which are important to understand. This is important for a number of reasons. You can bring a TUTSA and a DTSA claim in the same case, and you can seek different forms of relief based on them. The impact of having them in your lawsuits is also important thing to consider. DTSA obviously creates a question of federal jurisdiction that we'll look at more closely as we move along. So if you want to bring a case in federal court and you have evidence that supports the DTSA claim, that will give you 1331 jurisdiction. TUTSA also is obviously a state claim, and you can bring that exclusively if you want to bring a case in state court, and we'll explore the pros and cons. There are some differences that exist between the definitions. Both statutes require that trade secrets derive economic value, or that the individual owning the trade secret derives economic value from the trade secret not being generally known, and be the subject of reasonable efforts to protect the secrecy of that trade secret. A trade secret under TUTSA, however, does not need to be related to a product or used in interstate commerce. That's obviously the Commerce Clause hook for the DTSA. Also, unlike the DTSA, TUTSA expressly includes within its definition a list of actual or potential customers or suppliers. That's identified as an area that could be a potential trade secret. That's not to say the DTSA doesn't recognize that, but that's not expressly included in the definition. DTSA, on the other hand, provides that trade secret information can be tangible versus intangible and stored, compiled, or memorialized physically, electronically, graphically, or photographically. TUTSA does not. Doesn't have a similar provision, although again, looking to the case law, it's not conclusive that because that language is absent that won't be recognized as a trade secret. Ex parte seizures, DTSA expressly allows for ex parte seizures based upon an affidavit or verified complaint. In extraordinary circumstances, a court may issue an order. The terms of a Rule 65 injunction must be found to be adequate. There's no similar provision in TUTSA for ex parte seizures, but the law does, under 134A.003, provide that in appropriate circumstances, affirmative acts to protect a trade secret may be compelled by court order. So there are ways to work with both of these statutes if those are of interest to you, and the differences are important to remember as you look at the evidence that you have that a trade secret has been misappropriated and determine the next steps. The DTSA contains a unique whistleblower provision. It's designed to protect whistleblowers. It provides that an individual will not be held criminally or civilly liable under federal or state secret law for the disclosure of the trade secret that was made in confidence and solely for the purpose of reporting or investigating a suspected violation of law, or made in a complaint or other document filed in a court proceeding as long as it's filed under seal. We've spent a lot of the last few years since DTSA has been enacted to encourage employers to update their contracts with this language to incorporate these provisions, because failure to do so bars an employer from recovering exemplary damages and fees against the employee who misappropriates those secrets if that agreement has been issued since the passage of the DTSA. TUTSA does not contain these whistleblower provisions or impose duties to notify employees of these protections, but obviously this is something that you will want as you move forward in deciding which law or laws to bring your cases under. So an important thing to remember here on this point is if an employer has not complied with DTSA's notice requirement, the employer may still want to assert a TUTSA claim if it can establish that an employee has willfully and maliciously misappropriated the trade secrets, because it would still then be able to recover attorney's fees and exemplary damages under TUTSA, even if that's not permitted under DTSA. And then there's claim preemption issues. Neither TUTSA nor the DTSA preempt contract claims based on trade secret misappropriation. However, TUTSA does preempt all common law claims that would otherwise provide civil remedies for the misappropriation of a trade secret. And you can't get around that by not pleading the TUTSA claim. That still remains your sole remedy. The DTSA does not preempt those claims, nor does it preempt claims under the TUTSA. The TUTSA will, however, preempt those claims. So those are some of the key differences definitionally. Next slide, please. There's differences in the types of injunctive relief that you can get. So, for example, injunctive relief primarily is similar in both cases, but the DTSA is more sensitive to protecting an employee's rights. Under the DTSA, an injunction may not prevent a person from entering into an employment relationship. So it cannot otherwise conflict with state laws prohibiting restraints on the practice of a profession or trade or business. So it kind of dials itself back and says if the state law, the DTSA says, if the state law provides restraints, it conflicts with some state law prohibiting restraints, the DTSA is not going to apply there. And so you've seen the interplay between those. Texas law, the TUTSA, that's not going to be at issue there. But TUTSA may allow for a former employer to prevent a former employee from moving into a position with a new employer. It can prevent that. The DTSA cannot do that. But under Texas law, it cannot prevent a former employee's use of general knowledge, skill, and experience acquired during the employment relationship. So both statutes allow for actual or threatened misappropriation, but I think the key difference here that we're looking at is that the DTSA is not going to prevent somebody from going to work for another company or otherwise gaining employment. The sought injunctive relief in those cases is going to have to be something more limited, while the TUTSA does provide and will allow for that as long as you're not preventing that individual from using general knowledge, skill, and experience. Next slide, please. So the ever-present inevitable disclosure doctrine or inevitable use doctrine, the similar issues. Texas, as far as I know from my most recent review of case law, does not expressly adopt the inevitable disclosure doctrine. Generally what the doctrine is, there are many permutations of it, but it's where a former employer is entitled to enjoin even anticipated employment or business activity that would result in the inevitable disclosure in order to protect the former employer's confidential and proprietary information from disclosure. The DTSA constrains the application of it based on the employee knowledge. So an individual can't be prevented from going to work for somebody just on what they know. That's a DTSA restriction. While there's no express adoption of the inevitable disclosure doctrine in Texas courts, there have been multiple courts that have recognized, multiple appellate courts that have recognized some version of it. And what they'll look at is they'll look specifically at what the person, the position that they're going into, and determine, well, can they perform that role without taking advantage of that information. There's this sense that you cannot be a good employee in your new position knowing the information and being prevented from, you can be prevented from taking that position if you can't otherwise bifurcate your mind in those circumstances. So other Texas courts of appeals have refused to apply it, and they've looked to the Texas Supreme Court. And again, in the case of the LLC case, the Texas Supreme Court, and we have a blog post on our Trading Secrets law.com website that talks about this case in detail, and it goes back to this idea that you can't be a person in a position to make business decisions and pretend like you don't know something that is otherwise a trade secret issue. Next slide, please. So generally here we have the different types of remedies in trade secret litigation. You can see the differences here. We've put together in a chart differences between DTSA, the Uniform Trade Secrets Act, and the TUTSA. Most of these are, as you can see, the same across the board, although there are small distinctions that you can see across each of these charts. But ultimately, the general monetary remedies are similar with a few exceptions here. I want to spend my last minute or two here on the next slide, if we could, please, and that is the jurisdictional considerations. And so, again, coming back to the idea that TUTS is a state law claim, so if you just bring a Texas Uniform Trade Secrets claim, you will remain in Texas court. There's no basis for removal, and that puts you in the realm of the Texas Rules of Civil Procedure. And there are as many opinions on this as there are lawyers, but generally the idea of being in a state court can be favorable to a plaintiff. But it also, on the other hand, can be favorable to the individual over a corporation. And so you have to balance the individual facts and claims that you may have, and you need to consider where the venue is that you're going to be as you bring forward your claims. That you want to think about the variations in the rules with regards to protective orders, the liberal amended pleading standards that you have under the Texas rules as opposed to the federal rules, which are much more regimented. Also, the concept of getting to trial. Matt made a very good point that it takes a considerably longer time, I think, in state court these days to get to trial. However, there may be significant obstacles in federal court for a plaintiff in getting to that location, not so much in time, but in terms of having to meet the rigors of a 12B6 or a summary judgment. While there are analogs in state court, they are, at least in many people's experience, not as rigorously enforced, and materials tend to get to trial more in state court than they do federal. But I leave that to your individual experiences. So what's important to remember in all of this is simply that there are going to be impacts by the claims that you bring, and those claims, whether they're TUTS or DTSA, may shape your litigation strategy, either as a plaintiff or as a defendant as you're facing some of this. So with that, I want to put a final plug in, both for my colleagues who are excellent trade secret lawyers and for our 50-state survey, which we put together. Next slide, please. We have a 50-state desktop reference that we put together, and we update every year. It's available on our website, on our tradingsecrets.com blog, and you certainly can access it by shooting any one of us an email. And we have a host of lawyers Tier 1 U.S. News & World Report lawyers from across the country that are handling these issues, and we'd be very happy to address your concerns. So if you go ahead and put up our contact information here at the end, Colleen, and we'll open it up for any questions. So thank you very much for your time today. And looking to see if there's been any questions that have been raised here in the comment box. So Matt, I think this might be your question. Let's see if there's been an answer here, but
yeah, I just saw a question just real quick, and if we don't get to your questions, we will certainly respond directly to you via email. This question is essentially if the employee has global responsibilities over the entire U.S. and the globe, how does the geographic restriction play out in this scenario? So even though the responsibilities may be entire U.S., do their actual responsibilities cover the entire U.S.? Do you have, an employee doing work in North Dakota or South Dakota or Idaho? Sorry, I'm picking on all those states. Likely not. So by limiting, or Kazakhstan, by limiting it to just the states or the countries or even the, provinces within those other countries that they're performing services in on behalf of your company in the last year or 2 years, that's how you narrowly tailor an agreement to protect your business interests and goodwill.
Yeah, I would add to that too that I see a lot of employers when it comes to sales force selling products that they'll limit it to product lines. So the geographic restriction sometimes goes by the wayside, and it's simply a matter of you can't sell widget A because that was your responsibility, whether in terms of engineering and development or in terms of actual selling it. So if you sold it in a particular geography, that's going to be an issue, or wherever you sold it, but a shift of focus, particularly in R&D, to a product over geography. But I think it's it's very fact specific, as Matt has said. All right, everyone. Well, thank you very much again. This is our comments or our emails. So feel free to email us comments or questions. We're happy to follow up with you. Give us a call, and we will follow up with you individually. And appreciate your time today. We'll give you back the rest. Thanks so much.